Hey everybody, happy Friday. Hope everyone's doing well. Nice to see everyone. The sun is finally out and the temperature is actually getting a little warmer. No rush in getting warm. We'd like to be a little warmer. It's been kind of cold the past couple days. But it's nice to see everybody. And so we're going to have next month is going to be at 4 o'clock also. And the following month we'll move to what? Noon, Eileen?
Yes,
Okay,
2
so
hours.
next month we'll be at 4, and the following month will be at noon. So we start summer hours in June. So good to see everyone. So today's topic is radical transparency and Florida House Bill 913, which was effective January 1st, 2026. And why do I care about Florida law? Right. The reason we care about Florida law actually is because a lot of it winds up translating into New Jersey law eventually. We used to think that Florida, South Florida especially, was a suburb of New Jersey and New York, but in some ways it seems like New Jersey and New York are becoming a suburb of South Florida. So it's kind of weird. It's flowing the opposite way these days, at least legally, it seems, with respect to community associations and condo associations. So first things first, right? The announcements. These webinars are provided for general informational, educational purposes only, not legal advice. And not intended to create any attorney-client relationship. And if you want to go get an attorney, you can go out and hire us, which we would love. If not, you go out and hire somebody else and sign a fee agreement, and that's all good. The last thing is nothing is confidential, so don't put any wacky stuff in the chat that you don't want disclosed. So why do we care about radical transparency, which is happening in Florida? And I'll give away the secret that's not on the agenda. So the question that I think we should be thinking about when we talk about radical transparency and the transparency requirements in the Florida law is, can this be an alternative to fully funding non-structural reserve plans? Can this be an alternative to fully funding non-structural reserve plans? Now, obviously, that would take a legislative amendment to the act, PREDFA and the regulations to address that because you're required to fully fund one of your plans, whether it's the full funding plan, the threshold plan, or the baseline plan. But the question is, if you had radical disclosure and did not fund um, did not fund the non-structural reserve items, would that be enough so that the people could see, hey, here's the reserve funding plan, and this is where the association is vis-a-vis the cash flow and the cash balance with respect to that plan? That's a question. It's just, I thought it was interesting when I saw this act. We have some other things coming up in the next couple of months that are like new and different, FHA stuff and all those other good things. Um, but I thought this was interesting because it is new. So, um, dog of the day, right? Dog of the day. We missed
Okay.
dog of the day.
Yep.
There we go. I hate missing dog of the day. We got to have our priorities straight, right? So that's Lexi and Bowie, and they are owned by Stacy Homa, and of Realty Solutions. Realty Solutions is in Audubon, New Jersey, but they manage properties all over the state. And thank you so much, Stacy. And let's go back for that for one second. Sorry, Crystal. So people are now wising up and they're starting taking pictures of their dogs aimed at right holidays. So Stacy's in there looking at, you got a flag behind there too if you pan out a little bit. There you go, looking for the 4th of July placement on the coming year's calendar, right? So this summer, they won't be on this summer's, but this summer we're going to celebrate what, 250 years of the United States, freedom, all those good things. And Stacy is aimed at the 4th of July and the month of July for the calendar. So thanks, Stacy. Very nice looking dogs, very happy looking. So let's talk about radical transparency. So this is what's happening in Florida now. Um, and again, keep in mind this discussion is only with respect to the new Florida law. Nothing is pending in New Jersey with respect to this. But it applies to associations with 25 or more units, right? Website or app with members only page. So you'll have the association's regular web page, and then you have to have a password protected members only section that you can go through and log on through the main website so that it's members only. On the members only portion, you have username and password protected, and you have copies of the recorded governing documents. You have rules and regulations. You have the meeting minutes that goes back 7 years. My gosh, Fran McGovern, that's crazy. 7 years of minutes. We can't find our minutes from last week, right? So that's one thing that you're going to wind if an association were to choose to do this, whether there was a law adopted requiring it or whether the association chose to do it voluntarily. Posting 7 years of minutes is going to be very daunting for many associations. And if you don't have them, you don't have them. But if you start the process, they would accrue over the years. List of executory contracts and list of bids within the past year. So executory contracts are contracts that are still live and in effect at the moment. So a landscaping contract that is applicable now, and the bids within the past year for those contracts. So you'd have to disclose, hey, these are the executive contracts, and with respect to the executive contracts themselves, these are the bids we got. The annual budget, right? Seems normal. Monthly financial statements, right? Monthly financial statements. Transactions between the association and interested parties. This is pretty rare, but we do have a couple of associations that represent where, for example, a board member may have her nephew who owns the snow company, snow removal company, things like that. So you would have to disclose online any and all interested transactions or any and all conflicts. So documents addressing conflict of interest. So you'd have to document the fact that there was a conflict of interest. The conflict of interest was addressed in the following way. The board member recused himself or herself from the meetings and discussions on the issue, etc. So you have to document that. Meeting notices and agendas. Here's your structural inspection reports, most recent reserve studies, building permits for planned construction, right? So that's pretty darn comprehensive. And New Jersey has nothing like that at the moment in terms of making them available to your members. As you know, the people most of you, I look really super familiar. It's nice to see again, who have watched me on First Friday with Fran. I am a huge transparency advocate. And since we're membership organizations, I'm a large proponent of making things available to the association membership. So I think it would be a good idea, whether this is a Florida law or not, or whether it's a New Jersey law or not, for associations to start exploring how realistic it would be to create some or all of these pages in your password protected membership area. It would also take us, in my opinion, a significant load off your property managers, because what happens, and the property managers out there know this, invariably you get a homeowner who is needling the manager, saying, I need this document, I need this document, I need this document, etc. And even under a current New Jersey law, producing it via an internet portal, in my opinion, would fulfill the association's obligation to allow a member to inspect the books and records, right? So we deal with those issues all the time. The association is not providing me with access to the book and records. I want to come in and sit with the manager at the conference table, et cetera, et cetera. How many managers want to sit with the angry homeowner and review books and records? Look at the binder. Nobody, right? Nobody wants to do that. So that's kind of the question for today. How many people out there would be interested in taking on something like this, and how many people out there are undertaking something like this already? So many associations already publish their minutes online, already publish their books and records online, budgets, etc. So I'm curious to know how many people would believe that this type of transparency would be an alternative to fully funding non-structural items. I don't know if that would be a very attractive alternative, but especially in associations right now, there are many associations that we're seeing out there that are not complying with the reserve funding laws. And what they're saying is, Fran, we just can't afford it. We just don't have the money. The people don't have the money. We could pass whatever budget you want, Fran, but we are not going to be able to collect the money from the people who live here. And that's the challenge. So I wonder whether disclosure and perhaps even recording something in the county clerk's office that says the association is not funding would help associations in terms of a possible liability issue if they're not properly funding. So anyway, that's the disclosure portion of today. I know that's pretty quick. There's nothing really in the chat today. I was wondering, does anyone have anything in chat? It doesn't have to be completely on topic. Um, but that was pretty brief today. And I'm not trying to rush through, but I have a trial that starts on Monday as well, which is joyous, right? We love that. So it's unfortunate, but I do have a trial that starts on Monday. Um, Anything for anybody? I don't want to take up time if we don't have to. But so that's the question. Are we going to see this type of legislation? Is the legislation going to be anyway tied to reserve funding, especially for non-structural items? And is it a viable alternative to funding for non-structural items? That all aside, how many associations would be willing to do this without any legislation? And again, I would encourage all the boards out there to consider doing this regardless of whether or not it's passed as legislation. Okay. Okay. So there are a couple questions. All right, I'll address them before we go. So Anna said, "Hey, it provides a good outline for the website," which is right. So you can tick off the points. That's good. Examples of non-structural items. So the one we always use and talk about is the the reserve studies. Not only do they include structural items, they include non-structural items. So you're required, in theory, if you have a condo association, to replace shutters. You're required to reserve for those shutters. They're non-structural, structural. They're decorative, but you still have to have a line item in there for that. And a lot of associations are saying, well, Fran, why do we care if the shutters are at the end of their useful life? We don't really want to go out of pocket for replacing the shutters. We know they're blue, we know they're faded. We're not worrying about it. But why do we have to put money away for it? This is not Disney World. So, and by the way, our homeowners don't have money. Keep in mind, all this reserve funding stuff, which is best practice, and I am a huge fan of, um, has happened in an up market. So since this stuff has been adopted, the real estate market has been going up, 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 up. So everyone has equity in their homes. But imagine if this reserve funding law was adopted in 2009, right? When nobody had equity in their homes. People would be in a panic. It just would not work. So it's going to be interesting to see how this plays out. Um, if I shouldn't say if, when we have a down real estate market, right? Because everyone knows in the United States, it's cyclical. The economy is cyclical, and we don't know what's going to come next. So it's going to be interesting to see how it plays out. Examples of non-structural, we said shutters is a good example. When resident seeks a copy of existing contracts, does the association have the right to say no to copying? No. If you have an existing contract as part of the books and records, the contract should be produced. There may be some contracts that have certain items redacted. But generally speaking, the association's members are entitled to copies of the contract. Again, and we've talked about this in the past, I like associations adopting a document retention policy, which would include document retention, production, um, and destruction, right? Policies in terms of how long do we have to keep documents? What do we do when they're past the time? Do we shred them if they're paper? Do we keep them if they're electronic? Et cetera, et cetera. And just so that document production and inspection of books and records is not used as a tool to harass the board and membership. I'm sorry, to harass the board and management. The reason for that is there are some people who just want to hammer management. Give me, give me, give me, give me, give me. I need another letter. I need another letter. I need another letter. I need another letter. So it winds up sucking up your staff time and it winds up sucking up board member resources as well sometimes. So, for example, copying charges, et cetera, in a document retention resolution, you would want to address all those things. Recent Fannie and Freddie requirements are apparently more strict than the New Jersey law. Example, no older than 3 years and no baseline funding. We will be discussing this in the future. Yes. So thanks, Wayne. We will be discussing that. I'm actually doing a seminar on that next month in Atlantic City. But I will be doing a First Friday with Fran probably next month on that as well. And then I have something already booked for May. I already have something booked for June. I forget the topic right now, but we'll probably be doing the Fannie Mae requirements in May, and then I do a topic already booked out for June, but I will be announcing that. So that's a good question, Wayne. The answer is yes. It's always somewhat controversial. There are some associations who want to be compliant, and there are some associations who don't want to be compliant, right? So it always winds up being a bit of a hot topic because many association board members are like, Fran, we want people to come here who have money. We don't want people to come here who don't have money, and that just gives you more collection work, Fran. We know you're overjoyed with that, but we don't want to be giving you collection work when we have people moving in with no money. So it's a hot topic, and over the years, I've probably spoken about this. I have had I have had various attorneys threaten to sue associations I work with for not being compliant and not, basically forcing people to go conventional and everything. And I have not seen an actual case on that, though, that says that an association has a duty. But we'll talk about that more next month. How would you handle storage of docs? The property manager we use holds the docs. If we change companies. Okay, so the property manager we have holds the docs if we change companies. So Lynn, that's not appropriate. The documents, whether they're a lawyer or an engineer or a management company, the association's books and records belong to the association rather than the management company. So, and I've had that in several cases, and I don't like to make it my business to sue management of companies, of course, but I have because certain management companies have refused to turn over the association's books and records, and I can tell you immediately judges will order the books and records released. So judges will file the suit, and the judge will say, give the association the books and records, and the management company will say, oh, well, they still owe us $1,500. And the judge will say, that's nice, turn over all the books and records. I'm then going to transfer this to the law division, and you can argue about money for as long as you want. But the association needs all of its books and records to function on a day-to-day basis, and you can't hold the association hostage, right? No judge is going to allow the association to be held hostage. We have a difficult time getting the docs back. Yeah, so I don't know, Lynn. It's if whoever your attorney is, I don't know if it's us or not, but if a management company, if the relationship's ours and the association moves on, judges will right quick order the books and records be turned over. That doesn't mean the books and records are going to be in beautiful, pristine condition because some management companies already they were a mess and they've been a mess for years. Many of the ones we work with, not that way, not that way. We try to avoid that if we can, but we do have some that are, they could be better. But a court will order them turned over. The baseline for the new law is 25 units or more, but not 3 stories or more. Correct. So Lou, this new law is only Florida law. It's not New Jersey. I'm just using this as an example. So I'll say it again. It's not New Jersey law, but the in Florida, the baseline was 25 units that they created. It has nothing to do with the actual number of stories or the structural elements themselves. I'm just speculating. Can radical disclosure requirements serve as a proxy for putting the money away, especially if it's non-structural items? And I don't know. Do these rules extend to invoices? So Lynn asked, do these rules extend to invoices? In Florida, it doesn't look like they do, but if New Jersey were to adopt a rule like this, they probably would. But it really depends. I mean, that's pretty extensive. But what we're going to have here, I think, eventually with AI and everything else, it's going to become, I think, almost seamless, such that the association management companies, at least the good ones, will have pretty robust software programs that are integrated with the association's website platforms, and those platforms will automatically upload into the members only portions. Remember, this is members only portion. This is not to the public. So I think, Lynn, if I was in front of a judge in New Jersey, and again, put the website aside, if I was in front of a New Jersey judge and a member said, hey, Fran, I want the invoices, I think I would lose the argument if I said they're not part of the books and records of the association. The association would be told to turn them over. Oh, Lou is in Florida. Lou, God bless you in Florida. Nice to see you. Yeah, I am not a Florida attorney, by the way. I'm glad. I hope you're enjoying yourself in Florida. I wish I was there. It's still a little chilly here. So that's good. But so certainly this is never legal advice, but it's certainly not legal advice in Florida. I don't want to get dinged for practicing law without a license in Florida. which can be a bit dicey. Eileen and I were talking about that today with respect to Florida and New Jersey, because some Pennsylvania attorneys without licenses in New Jersey will practice in New Jersey and vice versa. And that will get you into a world of trouble with the ethics committees. If you're not admitted, judges are not going to be happy, and the ethics board is not going to be happy either. Somebody had a hand raised. Ed, I'm going to go. Oh, we lost Ed. Margaret, you want to talk? Yeah, there we go. You got me? You
There you
should be
go.
able to. There we
Yeah.
go.
Hi.
Sure. Hi.
So this is an interesting conversation because the management company we use Premier. They're in
Uh,
New Jersey, in Inglewood Cliffs or Inglewood.
yeah.
And yesterday we were over there because they happen to use Vanica, and Vanica is structured like this so that it doesn't have a portal. It's password protected, and they use that for their association. So we were
Nice.
over there yesterday cleaning up the folders so that once a homeowner or a board member goes in, it's really clean. They can go in and find out what's going on. So and
That's great.
and and it does help. It helps tremendously. It's a pain setting it up, but once you get it going, it's a good process.
Oh, well, thanks, Margaret. That's great. So, see, we're already there with some companies and some associations. So that's great. Now, Margaret, just let me ask you a question. So, is that just for the board member access, or is it a porthole protected for members as well?
Both. And homeowners can also pay their maintenance fee. They can download the governing documents, like you said. They can find the forms for modifications.
Right.
They can see our financials. So
Okay.
all of that um, is
Yeah.
is already up and running.
I love it. You know, the only downside to all of this is that people hate the truth. People hate the truth, right? So, and the reason I say that is I was at a board meeting 2 weeks ago giving a presentation about how the association is not properly funded and hasn't been properly funded for 20 years. And there was a guy in the back screaming, scam, scam, scam. And what I was trying to tell him is there was no scam and nobody stole their money. They just did not budget properly for the past 20 years, right? People kept the monthly fee really low. And what's happening is now, as people are becoming more transparent and seeing the financials, in particular because of the reserve funding requirements and the reserve studies, everyone's in shock and they think someone stole our reserve money. Nobody stole anybody's reserve money. It was never there to begin with. So, so that's great. And thanks, Margaret, for that. Now, I have to go to Ed because his hand is falling off. So, hey, Ed.
Do we or do we not supposed to take minutes at board meetings and publish them or have them available either by Zoom or in print? This says yes. I know we've been operating, best of my knowledge, is we're not supposed to record them. So I'm very confused.
So when you say record minutes, you mean like audio record?
Yeah, we're on Zoom and we record them. Is that okay?
Okay, so
What
if
about just regular minutes taken by hand by the secretary?
so a lot of people record the minutes. When I say record, I mean audio. That's not minutes. That's an actual audio recording. So audio recordings have to be preserved for at least 30 days. And once you approve the minutes from that, those minutes have to be available to members. There's no law that I know of right now, like the Florida law, that requires them to be posted online, but you certainly have to produce them to the members if they ask for them, right? But I think it would be best practice to just make them available, to be transparent, right? I mean, there it is. And that's why I say it, in a way, per Margaret's point, it sets the board free once they have it all set up, because the information's out there and you don't have to torture the manager and torture the board members to get it. The one thing I will caution you, Ed, and you look like you might be a year or two older than me, um, so you probably know this already. People sometimes say really foolish things during meetings, right? So that's one of the downside of actually um, recording meetings. People say foolish things, and even if they say foolish things, under the law, you're still required to preserve them for at least, I believe it's 30 days off the top of my head. So you have to be careful about recording. Um, Thanks, Ed. That's a good question, though.
Yes.
Let's see. Our property management company provides front steps. They rarely put meeting minutes or other things on front steps. The on-site manager is indifferent to doing something about fixing it. In open board meetings, the board doesn't seem to care. What option does the owner have to get them to put these on front steps? So that's a question from Bill. Bill, it doesn't sound like you're a board member. So I would put a request in that as a practice to communicate with the membership. I request that they be posted to front steps, and I assume front step has a portal for members only, which again it's not required by the law at this point, but I think it will be in the near future, and it's a good practice anyway. Why would you not? And it doesn't, I don't think it really shouldn't be something that the on-site manager or the assigned manager, portfolio manager would have to do herself or himself. In theory, it should happen through, um, through the software package. Nicole says, don't draft minutes, have to be published. It's a timing thing, Nicole. I haven't looked at that recently, but it's a good question. It's a timing thing in terms of when the minutes are supposed to be put out. So you can't just sit on minutes forever because you just say they're draft. There's a big difference between showing the financials and showing the details underlying the account. Recently, our treasurer bought into investments that were not consistent with our bylaws. And when I called them to account, they tried to cover it up by initiating a bylaw amendment. Fortunately, it did not pass. So, Wayne, that's Justice Brandeis, right? That's Justice Brandeis when it comes to transparency and shedding a light on problems, right? So transparency, free speech, things like that are the best cure to things going wrong, right? Transparency helps avoid those things. So I again encourage that people to do that. And those who are on the call who are there involved in finance committees and things like that, whether you're doing tiered CDs or bank accounts or any other type of investment vehicle, please, please, please check your governing documents before you move money around. Because again, we're in a time, and I am not a market guy, but we're in a time where we've seen the market go up, 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 up. And when you see the market go up for a long time, everyone thinks it's going to continue to go up forever, right? That has never happened, right? That has never happened. I'm not saying the market's going to stop tomorrow. I don't know anything about the market, quite honestly, except for the fact that it is cyclical, and what goes up tends to come down at times. Then it goes up again, comes down, etc. So you don't want to get caught with your pants down. In the early 2000s, during the dot-com bubble and bust, there were several of my associations who said, Fran, oh my gosh, this market is going crazy. We're just going to take all reserve funds. We're going to put them in, balls.com, sports.com. And they did not do that because I told them you're out of your mind. Some of them said, Fran, we would have made a fortune. Other ones said, thank God, because we would have lost our shirts. We'd have lost everything. Because keep in mind, reserve funding is largely preservation of capital that is earmarked for particular items. It's not to speculate in the market, right? So please check your documents. I know some of you are investment professionals, so you can counsel your people on that. I'm not. Thanks, Wayne. What else do we have out there? It looks like that's all we have. So it was a quick one today. We're like back on schedule. That was 35 minutes. So that was real quick. It's good to see everyone. I hope everyone has a happy Friday, and I will see you in May. Thanks, everyone. Good seeing you. Take care.